against Dr. Conrad Murray. They got it. Is it enough? Prosecutors David Walgren and Deborah Brazil join me now, along with InSession correspondent Beth Karras. And Beth, I'm going to toss it to you with the idea that, boy, we watched that reaction and there was none. So you have to think on some level, Dr. Murray knew what was coming.
Probably so, Christy, and good morning to you. And I want to thank David and Deborah for joining us. I know that they're still on Pacific time zone, so they're pretty tired this morning. David, I want to start first with you and ask you about the sentencing yesterday and Judge Pastor's verbal assault on Conrad Murray. I mean, he really came down on him. Didn't just throw the book at him for the 4-year maximum term, but he spent more than 20 minutes giving his reasons for denying probation and imposing the maximum sentence that you asked for. Were you surprised at some of the harsh language that Judge Pastor used?
No, I wasn't, and I wouldn't characterize it as a verbal assault. I think the judge had sat through a very lengthy trial with a large number of witnesses, a lot of items of evidence. He was very well aware of the facts of the case and the evidence that had been presented. And I think he, like many others, was offended by Conrad Murray's actions and was expressing that, expressing what he had observed being proven to the jury, expressing the jury's findings and expressing his feelings about the actions of Conrad Murray. So I've heard it described as harsh. I didn't find it as harsh. I found it as an expression of how offended the judge was by Conrad Murray's just extreme negligent behavior.
You know, there was a point when he was going through his 25 minutes sentencing where he used the language of the statute for involuntary manslaughter, and the theory here, this conscious disregard for the risk of death or conscious disregard for life, the same language that's used in one of the theories of second-degree murder. And it made me feel that Judge Pastor may have felt that this actually is a murder case. Didn't these facts fit second-degree murder, the implied malice theory?
Well, Beth, what I'll say on that is, at the time this case was filed, all the possible charges were considered, and it was not an easy, quick decision. It was a very serious undertaking by my office. The case was reviewed, the facts were reviewed, the law was reviewed by a number of people, and through a kind of consensus of opinion, a decision was made to file what was felt to be the most appropriate charge, which was involuntary manslaughter. So although there have been comments regarding second-degree murder, it certainly was something considered, as is considered in all cases. All the relevant charges or possible charges are considered, but the decision in the end was made that involuntary manslaughter was the most appropriate charge that fit most appropriately the actions of Dr. Murray and what had transpired, namely on June 25th, 2009.
Right. Let me ask you, Deborah, about another thing that the judge said. In his sentencing, he said that Conrad Murray is a danger to the community. Do you believe that he is a danger to the community, really, if he can't practice medicine?
Yes, I do. And it is not simply the risk that he would administer propofol in the similar unsafe conditions that he did to Michael Jackson, but you have to evaluate Conrad Murray's overall medical judgment, the ethics that he employs when practicing medicine, which is a privilege. And he clearly, through his conduct, abused his education, his training, and his Hippocratic oath. So I do believe that Judge Pastor was accurate in characterizing Conrad Murray as a danger to society.
Now, what did the probation department recommend for a sentence? I know that the report, I believe, is now going to be public, but I didn't hear in court what they had recommended.
I did not hear Judge Pastor comment on what the probation officer recommended either.
Can you tell us?
Beth, the probation officer had recommended state prison as well, and had filed a very lengthy report, had interviewed Mrs. Jackson, and we had made reference to that in the sentencing hearing. And the probation officer felt that probation although the defendant was technically eligible for probation, this was not a probationary case, and the probation officer did recommend state prison.
And we were informed by the Sheriff's Department yesterday that they, by the way, do not consider him a house arrest candidate. He doesn't qualify for house arrest, so he's not going to get the Sheriff's Department version of probation either, at least for the time being. Can you tell me, David, or tell us a little bit more about what Katherine Jackson had to say in that probation report? I know you mentioned a few of her comments in court yesterday. Is she the only Jackson family member also who was interviewed?
Yes, and she spoke for the family and for the children. And in essence, what she said is there's not a single day that goes by that she doesn't wake up and think of her son, Michael. That Michael meant the world to his children, and the children meant the world to him. And that his children have been devastated by this loss. She described their future plans together, that the children wanted to get into filmmaking with Mr. Jackson, that they had plans to do this as a family together. And she just expressed quite eloquently just the devastation that has been wrought on the family as a result of Conrad Murray's actions. And she too expressed to the probation officer that she felt that he should receive the maximum sentence, which is what we asked for, which is the 4 years that Judge Pastor, we feel, correctly imposed.
Yesterday, you also mentioned that she said that Conrad Murray never consoled her at the hospital right after Michael Jackson died, contrary to what he had told the police in his statement 2 days after Michael died. Can you tell me a little bit about that? And has he ever expressed any remorse to the family?
I can tell you what Katherine Jackson expressed to the probation officer, and she was quite clear, and that is that she said that Conrad Murray was lying, that while at UCLA he never consoled her as he had described in the interview, that did not take place, and she expressed, in essence, her outrage that he made that statement, which she said was a lie.
Mm-hmm. So let me talk to you about the investigation and the trial. When did you first get this case? Was it once it was a homicide, or during the course of the death investigation?
I became involved in the case during the investigative phase, not immediately, but some months after June 25th, 2009.
Okay, so, and I want to talk to you about that investigation because, there were some issues at the trial where some errors that were made were pointed out very effectively by the defense, which, theoretically could have derailed the case if the, jurors were looking for an out there. And how much did that concern you? And what's your advice to the coroner's office regarding collection of evidence?
Well, in hindsight, every case has areas that could have been changed or improved, and it's easy to sit back after the fact and say what would have been done differently. I think early on this was being pursued as a coroner's investigation, somewhat unique in that the police involvement, although they were directly involved, they were working in conjunction with the coroner's office because it had not been ruled a homicide, as you referenced earlier. The coroners collect evidence and pursue a case to determine the cause and manner of death, and that's what they did in this case. Were there mistakes made? Yes, there were, but did they impact the evidence as it pointed to the guilt of Conrad Murray and him being the cause of Michael Jackson's death? No, it did not. So I'm a little hesitant to sit here and second guess what was done. I have not had a case in my career that was done perfectly. There are always mistakes made. These cases are investigated by human beings, and mistakes are always made. But I think everyone was pursuing the truth and trying to find out, again, initially the cause and manner of death, and then more specifically who the perpetrator was.
When you were first assigned this case, you're talking about the death of the most famous, the biggest pop star in the world. What obstacles did you foresee in the case? Was it that you had a celebrity victim?
You know, as best I could, I didn't view it through that angle as to, you know, that it was a celebrity victim. I tried to view it, and I did the best I could to view it as a homicide case that needed to be investigated thoroughly and properly and presented to the jury as clearly as possible. So I did the best I could to treat it as I would any other case. And although you can't ignore the fact that the victim was Michael Jackson, you cannot ignore the fact of, you know, the interest of the fans outside the building, or the interest of the media and the cameras in the courtroom and things of that nature. The fact is, I did try to just pursue it as I would any other homicide case.
But there were things about Michael Jackson that people knew, or opinions people had about him, whether they were true or not. I mean, he had been on trial in north of you in Santa Maria a few years earlier, acquitted, not guilty of child molestation, but there were people who believed still that he was a child molester. I mean, did that play a role? I mean, you had to be careful, right? You had to try to get some rulings in advance to make sure that wasn't going to be brought up.
Absolutely, because we thought it was entirely irrelevant, and the judge agreed. It was also something we had to deal with during voir dire. It was something we needed to make sure that we could pick a jury where the jurors were prepared and able to be fair jurors and to base their decision on the facts and evidence in our trial, in our case, and that they weren't coming in with any particular agenda or bias against one side or the other. So absolutely, that was something we were concerned about and prepared for, and tried to effectively deal with through the use of a questionnaire, also through the use of evidentiary hearings prior to trial, to get correct rulings as to the admissibility of evidence that we thought was entirely irrelevant to what was the issue at trial, which is the conduct and the actions of Dr. Conrad Murray.
There was another issue that concerned you too about Michael Jackson's past, and that was drug use. And let me play you a soundbite from juror number 5, Debbie Franklin, who spoke to HLN's Jane Velez Mitchell, and she addressed the addiction issue. Let's listen.
In the end, to us, it didn't matter that whether he was an addict and what he was addicted to. It came down to what happened between 10:30 in the morning and basically 12 or 12:30 that afternoon.
And so Debbie Franklin says they really didn't care if he was an addict, but you did work very hard to make sure the case was streamlined and that there was not going to be a trial within a trial, that Michael Jackson was not going to be put on trial for any drug use in the past. And I just wanted you to react to what Debbie Franklin had to say.
Absolutely, and it's nice to hear the comment she made, because I think she's exactly right. The issue was, again, the conduct and the actions that took place during the relevant time period. The issue was not any alleged activity years prior or things of that nature. There was a focused issue, a focused presentation of the case, and I think the jurors got it exactly right, as summarized by this particular juror that you just highlighted.
Great. Well, David, I have a lot more questions for you and Deborah, but it's time now to take a break, so back to you, Christy.
Break, thank you so much. We're not done.